This is the continuation of previous video where we will discuss the introduction of the CPC. Um, the previous video have ended with the introduction of section part of the CPC. We have already discussed in the previous video that the CPC had divided into two categories. The first part is substantive parts, that is the sections, and the other part is procedure part, which are orders given in the first schedule. So in this video we will dive into the concept of substantive part of the CPC, where we will first discuss the sections of the CPC. As the continuation of previous video, we have already discussed that the sections of CPC are divided into two groups. First is preliminary provisions, okay, which runs from section 1 to 8, and the other provisions which are divided into 11 parts, which runs from section 9 to 158. Okay, so in preliminary section 1, it provides commencement, and applicability of this code. Okay, commencement means as we have already discussed, the CPC has commenced on 1st of January 1909, and its applicability is whole of India except two things. First is state of Nagaland and the tribal areas as mentioned in our constitution. So the very first section of the CPC provides the commencement of the CPC. So when the CPC 1908 have enforced in our country, and what's the applicability of this particular code. Okay, so as per section 1, it says that the code of civil procedure would be applicable to whole of the India except in the parts or areas of state of Nagaland and tribal areas. Okay, so in this particular section it is also given that the state government, okay, by notification, where so in their official gazette, Z always be capital for the gazette, can extend what the applicability, ठीक है, the applicability of this code in the area of the state of Nagaland or tribal areas. Okay, so it's a general provision, or it's a general rule that the provisions of CPC would be applicable to whole of the India except the state of Nagaland and tribal areas. It means कि CPC का जो भी प्रोविजन रहेंगे वो इंडिया के सारे पार्ट्स में एप्लीकेबल होंगे, केवल नागालैंड, स्टेट ऑफ नागालैंड और ट्राइबल एरियाज को छोड़ करके. बट देयर इज अ प्रोविजन गिवन इटसेल्फ इन द सेक्शन 1 दैट the state government, the particular state government, by the notification, whether in the official gazette, in their official gazette, can extend the applicability of this code, and the code of CPC, where in the state, in any part, in the whole of the Nagaland, state of Nagaland, or any part of the Nagaland, or in a whole tribal area, or any particular part of the tribal area which came within the ambit of that particular state government. Okay, so it's an exception to this general rule that though under section 1 the applicability of this code was restricted uh, to the state of Nagaland and tribal areas, but by the official notification as it appears or as it feels necessary by the government, it may notify that the particular code will be applicable in the part of the Nagaland or the whole of the Nagaland or any tribal area which came in that particular state. Okay, so then we have section 2, which is a definition clause. Okay, we will discuss many definitions here. Then we have section 3, which deals with different types of codes. Its constitution and its jurisdiction. Okay, so section 3 deals with different types of civil codes. There are how many types of civil codes, and what and how these codes are constituted, and what would be the jurisdiction of those different types of codes. Okay, now this would go to the section 3 to 8. Okay, this all things will be done in the section 3 to 8, where we will discuss the different types of court, their constitutions, how they framed, how they constituted, and what are their jurisdiction. Okay, so after section 3 we have part 1 of the CPC, which goes from section 9 to 35B, read with order 1 to 20. Okay, so in section 9 it would have given that civil courts have jurisdiction over it to try all suits. Which type of suits? All suits, those suits which are of civil nature, unless they are barred. How? Whether expressly or impliedly. Okay, so section 6 deals with the jurisdiction of the courts, of the civil courts. Okay, so the section 9 gives the general provision that all the civil courts have jurisdiction over the suits which is of civil nature. Okay, but there is a exception of particular general rule, is that if the jurisdiction was impliedly या एक्सप्रेसली बार्ड, ठीक है. इफ द कोर्ट वाज एक्सप्रेसली और इम्प्लाइडली barred from exercising his jurisdiction in particular suit, then this section would not applicable. Okay, and the particular court would not try the particular suit. Okay, after that we have a very beautiful section, section 10, which deals with the concept of stay of suits. It is also known as the doctrine of res sub judice. Okay, then after section 10 we have section 11, a well-known doctrine, that is res judicata. Okay, any person any student who is known with code of civil procedure, he is well known with the importance of res judicata and res sub judice in civil proceeding also and in education purpose also. Okay, now in section 13 and 14 we will discuss about foreign judgments. Section 15 to 21A regulates place of suing, so where a person can sue the particular suit in the court. Okay, so section 15 to 21A deals with the place of suing. Okay, after that it also lays down what does place of suing says, that it also lays down the rules regarding jurisdiction of courts, its objection to that particular jurisdiction. Okay, so from section 15 to 21A we will discuss the place of suing. There it means the jurisdiction of the courts. Okay, and the objection to the jurisdiction. These principles are done in section from the sections 15 to 21A. From section 20 to 25 it deals with the provisions of transfer and withdrawal of what? Of suits, appeals and other proceedings. After dealing with the particular principles of the CPC, we are now able to understand the concept of suits. So after that we will discuss orders. So order 1 to 4 we will discuss institution of suits, how suits are instituted. Okay, framing of suits, how suits are framed, parties, recognized agents, and pleaders to the suit. We will discuss all from order 1 to 4. In order 5, after the institution of suits, we will inform the other party or the defendant against whom the suits are instituted. So in order 5, the rules of issuance and service of summons are given. In order 6, the very fundamental point, that is pleading, was given. Pleading means plaint and written statement. Okay, so under order 6 we will discuss what does this pleading means. It means the plaint and written statement. That's why order 7 discuss about the plaint, and order 8 discuss about the written statement. So order 7 is regarding plaint, and order 8 is regarding written statement, set off, and counterclaim. Okay, remember, this is the very important part. The order 1 to 4, order 5 is regarding the summon to the person against whom the suits are instituted, and after that the plaints are filed, and then the other party or the defendant files the written statements, and the plaints and written statements together called as pleading. Okay, so this would be given in the we will discuss in order 6. After that we will discuss in order 7 the plaint, what would be the plaint, what the contents of the plaint, what would be the key elements or the fundamental elements there in the plaint which would have been there uh, uh, to not get the plaints as null or void. Okay, so then we will discuss in order 8 the written statement, the set off, what does this mean, what does this word means, set off, and counterclaim. We all the concepts of all these things we will discuss in order 8. After that we will discuss in order 9, after filing the plaint, written statement, okay, after summoning the defendant or other party, and after filing plaint and written statement, we will discuss in order 9 the appearance of parties. Here the word is used as parties. Okay, so this includes both the parties. Okay, the person who is filing the suit and the person against whom the suits are filed. So in order 9 we will discuss the concepts of appearance of the parties, how the parties would appear in the civil courts, and what will the consequences, of their non appearance. ठीक है, in the court when the court requires them. It also provides the remedy for setting aside what, the order of dismissal of suit of a plaintiff. Okay, and an ex parte order against the defendant. Okay, so in order 9 we will discuss the appearance of the parties. Okay, So order 9 requires the appearance of the party, and what would be the consequences of non-appearance of the parties. Okay, it also provides the remedies of setting aside the order of dismissal of the suit. Okay, and the ex parte decree passed against the defendant, sorry. So this is all for this video. We will discuss the other concept of the part 1 and dive into the part 2 of the CPC in the next video. So till then, thanks, and keep revising the concepts. Thank you.